adding her as a party to mislead the circuit court judge.
She is the presumptive owner of the property. She is the one who filed.
No, I didn't sign no paper here, no.
Did maybe an attorney file one for you here?
Yes.
100% believe that you are trying to play a game on the record in the matter Hamilton Road versus Claude Miller and Betty Miller. Can I have appearances, please?
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road, a representative is seated in the courtroom.
Good afternoon, Your Honor. Darwin Fair on behalf of all the defendants.
There's a motion to strike filings by non-party Betty Miller for writ to issue and for sanctions. Okay, and then there was a defendant's motion for reconsideration, which I set for an in-person hearing. There was a Betty Miller who filed in pro per. Is Betty Miller here?
She's downstairs. She can't come upstairs. She has panic attacks and she don't ride elevators. She'll freak out.
Is she in a wheelchair?
No, she's not in a wheelchair.
But we have a stairwell.
She climbed your stairwell back in January, I think it was, and almost passed out.
Okay. Well, she's filed this motion to the court, and then I'm assuming she's going to try to appear, I would imagine, in the circuit court or the Court of Appeals, wherever else this case may land. How is she going to get there? Because I can't proceed without her, and her son can't represent her in court.
Your Honor, if I may. Your Honor, if I may. Those.
Mr. Wait a minute. Everybody doesn't get to decide when they may. I'll decide who mays on today. I don't have an appearance from you, Mr. Fair, on her behalf.
It's our position Betty Miller is not a party, never was a party to these proceedings. The court is being intentionally misled by Mr. Fair. The trial in this matter happened on January 31st. This court awarded possession to Hamilton Road based in part because the occupants were not the same as the plaintiffs in the Court of Appeals case. Since then, a number of filings have happened that are Betty Miller in pro per. Betty Miller never was a party. Only Claude Miller and all occupants. There was no summons, no complaint ever issued to Betty Miller. She was never added as a party, not once. However, the Court of Appeals case, which is also ironically drafted in pro per, has Betty Miller as a party. So there's a unique advantage adding her as a party after a trial to mislead the circuit court judge. That was all done in pro per, but I suspect Attorney Fair drafted. I suspect this because we've located very similar cases in the Court of Appeals where Attorney Fair has argued and lost the identical issues. You have to pay it either to the plaintiff, Hamilton Road, or the Register of Deeds. And he's argued these cases on the Court of Appeals and he's lost. So we have Betty Miller's name on a Court of Appeals case. It was in circuit court and it was summarily dismissed. Identical issue, and they appealed the next day to filed a brief the next day and appealed it to the circuit court. When that hearing finally happens, after it, Hamilton Road is going to ask for sanctions for vexatious pleadings because it's our opinion all this is done for delay. Now here in this case, Mr. Fair originally represented that the defendants in this case were the same parties in the appellate court case. Your Honor discovered on your own, you asked the people to come into court and questioned them and found out that it was the Davises that were the actual occupants of the premises. And Betty Miller has never been a party. We had a trial now on January 31st. After the trial only, for the very first time, Betty Miller starts showing up in the caption of the pleadings. And I believe this was done intentionally to muddy the waters so they can argue in front of the circuit court judge that, oh yeah, Betty Miller is now the same party as the Court of Appeals. She's never been a party. She is the only one who has filed an appeal. There is no claim of appeal by the Davises. There is no claim of appeal by the estate of Claude Miller. Only Betty Miller, in pro per, but I suspect drafted. We never named her as a party, never issued a summons. We'd like her name stricken from the caption so that the circuit court does not get misled by why her name is suddenly showing up in the caption. Because we don't want them arguing, oh yeah, the parties are the same now. I've also asked that I've been attorney 33 years, 4 times have I asked for sanctions against an attorney. I believe this court has been intentionally misled by this guy, not once, but several times.
Correct, but they weren't to strike anything that you were on.
Well, okay. Well, we responded to.
I'm trying to understand why you're here. I don't have any recent filings from you.
They were rejected, Your Honor, by the empire.
The motion to strike, let's see, we answered the motion to strike. And that is what I thought that I would be arguing today. Also, I can speak to the issue of reconsideration, but Judge, if you don't want me to speak to it, that's fine.
Well, you can't,
But we
because you
did.
gotta, if you're gonna represent someone, you need to file an appearance. And you can't do what I suspect you're doing, which is try to hide behind the 8 ball and draft motions for someone to file on their own and then show up to court.
Well, no, Judge, I would never try to mislead the court like
Do you want?
Okay,
I'm
but-
gonna ask her under oath when she gets here if she drafted this.
No, Judge, it has it right here that it was done with the help of a lawyer. I did help her as a lawyer. It has it on the pleadings that must be in the pleadings that the document was drafted with the help of attorney. It has it right there in her motion for reconsideration.
Primarily, it was drafted with the help of you, correct?
That's correct, Judge.
I'm not clear. I don't know if you represent Mr. Davis. I'm not sure who you represent. Who do you represent,
Judge,
Mr. Fair?
Judge, if I may, Judge, if I may. We were going to file the motion for reconsideration. We were told that we were, for whatever reason, removed from the case. And we spoke to the clerk and they said it was inadvertent. And so what we did is, as quickly as we could, file the motion for reconsideration under Betty Miller, who is now before the court. But the reality of it, Judge, and not to put form over substance or make a distinction without difference, and, I just want to make sure, and I know the court understands our position is a distinction without difference. Betty Miller is the presumptive owner of the subject property. It is her husband who was on title, but she is his wife. So she is the presumptive owner of the property. She is the one who filed the lawsuit I'm the one who filed the lawsuit in circuit court for Betty Miller and the other defendants in that case. Then there was this.
I understand all of that. I've heard this probably 20 times already. I'm very clear. Did the circuit court grant you the relief you were seeking?
No, they did not. That case is currently before
and so you now are appealing that decision of the circuit court, correct?
Yes.
Okay. Has any court granted you the relief you were seeking?
What you mean in the circuit court?
You said it's before the Court of Appeals?
Yeah, they have not ruled on the case.
No, we're not dealing with ownership here. We're dealing with possession.
Yeah. Well,
we're not dealing with ownership.
Well, no, I get
and
that.
She came to the court and she let us know that she did not reside in the property.
No, I get that, Judge. There's no question she doesn't reside in the property. But if you evict the tenants, she's the one who suffers as a result of the owner. And I hear what the court is saying about.
I completely understand your position.
Okay.
You believe that the foreclosure was invalid and she should be the lawful owner of the property. Until the court says that, she doesn't get to act like the lawful owner of the property. You got to get a court to make her the lawful owner. You can't, by virtue of filing lawsuits, make her the lawful owner of a property. Ms. Miller, you can unmute now because I need to ask you since you filed this info first.
Your Honor.
Give me just a moment, please. Can you help her unmute, please? Thank you. Ms. Miller, can you hear?
Yeah, I can hear.
Okay. And so you filed a motion for reconsideration?
Yeah.
Okay. You're not sure what you filed?
I was at the court, but I don't know exactly. No.
What motion was it?
Okay, what motion was it?
A motion, it says defendant's motion for reconsideration.
Well, yeah, for that $5,000 you talking about?
Yeah, well, you filed a motion, it says on the 7th of this month, addressing the escrow and then also the $5,000 for the surety, a bond for the appeal, correct?
Yes.
Okay, and why did you file that motion?
Well, I guess it wasn't doing anything, so I was wondering what was going on about that and why we would have to pay the $5,000.
Okay, well, it was typical that you would need to post a bond for an appeal. I'm not sure why you were addressing the escrow because you don't live in the property, do you?
No.
Okay. And the escrow order was as to the occupants of the property. Were you aware of that?
Yes, not me.
Okay.
Yes,
so
he had said, he had told me about it.
Okay. How did you file this motion?
In the court.
You filed it in person?
I guess I was downtown, yeah.
Well, I'm asking you because you haven't been able to come upstairs. So did you go to the 5th floor to file this?
No.
Okay. So how did you file the motion?
I didn't sign no papers.
I'm sorry?
I went to the one on Kalamazoo Street. I went to the courthouse on Kalamazoo Street.
Okay, but this month,
And that was on the first place. I don't remember that one.
You don't remember filing any motion here?
No, I didn't sign no paper here, no.
Oh, okay. Did maybe an attorney file one for you here?
Yes.
You wanted to address the court?
Your Honor, a claim of appeal was not timely filed. You're being misled on that. The trial in this matter was January 31st. Your Honor signed a judgment landlord-tenant on February 16th. You have 10 days from February 16th, according to the court rules, that Mr. Ferrer wants to argue to file a claim of appeal. They didn't file one. They filed one on February 12th before Your Honor even entered the order. That's entirely improper. It says the appeal from the order must be filed after the order is entered, not 4 days before. And it really comes down to Betty Miller is simply not a party to this proceeding. Why are we adding her to the caption? It is a misdirection. It is intended to confuse the circuit court the same way he has confused Your Honor and myself. So that's what he does, and that's why they're all done in pro per, because ultimately they lose. He's argued the same cases, same issues, Court of Appeals, and lost.
Okay, I'll address the motions. There was a motion to strike the filings by non-party Betty Miller for writ to issue. That motion will be granted. Betty Miller is not a party in this matter, nor was she ever an occupant in this eviction landlord-tenant proceeding. So that motion will be granted. The motion for reconsideration is not properly filed, Betty Miller can't file a motion for reconsideration for the occupant, Mr. Davis, being evicted. If you want to represent her or help her improper to file a motion or a action in another court to stay this eviction pending her court of appeals, that's different. But you can't attach her to this matter the way you've been doing it. It's improper. I'm tired of the filings. I'm tired of the back and forth. I'm tired of having to find out who lives in the property, who doesn't. I don't want to see this case anymore, to be quite honest with you. Well, you represented Mr. Davis the entire time, supposedly, because your original appearance was for the occupant, which was Mr. Davis. It was never it was not Miss Miller. She was not a party. And because she was not a occupant in this property. You represented Mr. Davis. You could have filed your bond as it relates to Mr. Davis, or an appeal as it relates to Mr. Davis. That's not what you did.
Judge, I hear you, Judge. I do. I could amend all those pleadings if you want.
No, we're not going to play that game, because you're just like Mr. Turnbull said. He's been an attorney for was it 3 decades? I think that you have been an attorney probably a comparable amount of time, and you're well experienced. So I think you knew that if you were representing him, then you can appeal for him. That's why you had Ms. Miller file improper. That's my personal opinion. I 100% believe that you are trying to play a game as it relates to who filed what pleadings. Because even if the clerk's office inadvertently removed you as a party, they have to put you back on, because you always represented the occupant, Mr. Davis. At least that's what your appearance stated, so that you could file any motions as it relates to your client. But that's not what we got here. We got something from Miss Miller. We got multiple filings from Miss Miller. Then you appeared. That's not appropriate. You're trying to attach someone to this case who's not supposed to be attached to this case to get that order outside of doing it the appropriate way. So for that reason, the motion of reconsideration is denied.
Your Honor, we'd like the writ to issue. The occupants have not appealed. There is no proper appeal from this case, appeal in this file. Betty Miller, as your court ruled, is not a party. No bond has been posted. 10 days from judgment, and the judgment was entered February 2024. No appeal has been in.
Judge,
It's just been a charade, the whole thing.
What we've talked about before.
Okay,
And
I've already entered or stated what my ruling was. Any further banter is just between the two of you all. You all can get each other's phone numbers and knock each other out if you want to go back and forth. I don't need to be here for that. I don't need to be a party. I'm positive that you're going to put in a request for a writ. I'm positive Mr. Fair is going to go and file a motion to stay the writ and then file another filing. I'm positive that we're not done yet. I'm positive of that. But nonetheless, as it relates for today, there will be a order for a writ to issue, and I will note on the record that the bond appeal, let me find this motion to reconsider. Motion to reconsider the bond appeal is denied, as Betty Miller is not an appropriate party in this matter.